Welcome to our exploration of the law of agency. Imagine you need to sign a contract but you can't be there in person. The law allows you to authorize someone else, an agent, to act on your behalf. This is the essence of agency. One person, the agent, performs a legal act for another, the principal. The contract, however, is between the principal and a third party, not the agent. For example, if your parents are ill and authorize you to sell their car, you act as their agent, but the contract is between your parents and the buyer. Agency is common in business and everyday life, ensuring that legal acts can be performed even when the principal can't act personally. Throughout this video, we'll break down how agency works, who can be an agent or principal, and why this relationship is so important. It's important to distinguish between agency and mandate. While both involve one person acting for another, their roles differ. In a contract of mandate, the mandatory agrees to perform a task for the mandator, but this task doesn't have to be a legal act. For example, if you ask an estate agent to find a buyer for your house, the agent is a mandatory, simply bringing a buyer to you. However, if you authorize the agent to actually sell the house on your behalf, the agent becomes your agent in the legal sense. Sometimes, a contract can include both mandate and agency, such as when an estate agent is tasked with both finding a buyer and concluding the sale. Understanding this difference helps clarify the legal responsibilities and rights involved in each relationship. For an agency relationship to be valid, three key requirements must be met. First, the principal must exist. An agent can't act for someone who doesn't exist, though there are exceptions in business law for companies yet to be formed. Second, the agent must have authority to act on behalf of the principal. This authority can be given expressly, such as in writing or verbally or tacitly, inferred from the circumstances. Third, the agent must make it clear to the third party that they are acting as an agent, not in a personal capacity. If these requirements aren't met, the principal may not be bound by the agent's actions. We'll also touch on special cases like pre-incorporation contracts and the doctrine of the undisclosed principal, where the agent acts without revealing the principal's identity. Both the principal and the agent have important duties in an agency relationship. The principal must pay the agent for their work, reimburse reasonable expenses, and indemnify the agent for losses incurred while acting within their authority. On the other hand, the agent must always act in the principal's best interests, follow lawful instructions, exercise care and diligence, act in good faith, and properly account for all transactions. For example, if an agent is authorized to buy a 3-bedroom house but buys a 2-bedroom flat, the principal can take legal action for losses. If the agent makes a secret profit or acts negligently, they can be held liable. These duties ensure trust and accountability, making agency relationships reliable and effective in both business and personal contexts. Authority is central to agency. An agent can be authorized by the principal directly, by law, or by delegation. Sometimes agents act without authority. In such cases, the principal is usually not bound unless they later ratify the act or if ostensible authority applies, where the principal's conduct led a third party to reasonably believe the agent had authority. If an agent acts without authority and the principal does not ratify, the agent may be personally liable for misrepresentation or breach of warranty. Agency can end in several ways: death or insanity of the principal or agent, completion of the task, expiration of the agreed period, or revocation by the principal. Understanding these rules helps prevent disputes and ensures smooth business operations.